Welcome back to another episode of the Collaborative IEP podcast with your host, Ashley Barlow. That I'm so happy that you're here. Um, Man, this is fun. I have actually really enjoyed just preparing for the first two episodes of this series. So in this series, what we are doing is we are walking our way through idea. And we're going to go in chronological order for the most part. And I don't have it all planned out because, the two job thing. But I think our plan right now is to go in chronological order and to really, like, my goal is to get you access to the law and access to advocacy tips that are founded in the law, and to provide them to you in an easily accessible way so that you understand the law and it's not just words on a page or on a screen. Um, and so I thought what we would do, since this is a newer series, is we would go back into how we find this law. So I've got our next section pulled up, but here on my other screen, I'm going to go back a little bit and I'm going to tell you that we are in that idea part of the United States Department of Education's website. So through the DOE, you can get to the idea page, Individuals with Disabilities Education Act page. Again, I'll read the site to you, but it's probably better that you just Google it. https:// sites, SATES .ed, like education. It's also my brother's name. So fun fact, whenever I text Ed, it capitalizes it because of my brother's name and like four uncles. And actually both of my grandparents were named Edward John. We are a minute and 54 seconds into this podcast and I've already gone on a tangent, ladies and gentlemen. Okay. Sites.ed.gov /idea. That might get you where you are, but I think typing things into the search bar, like via Google or something, is way easier. When you get there, you get the law. We have already done, we are in subchapter 1, and we have already done section 1400, which was our findings and purposes. And now we are in 1401, which is definitions. So I'm going to go ahead and click on 1401 definition. Don't forget, you can find this other places on reputable sites like the Cornell website. So in theory, 1401 gives us our definitions for the law. And I think it's important to understand why we have definitions. Basically, definitions are key terms, right? It's going to spell out some things that we're going to see later in the law. So if you were ever reading part of the law, or if you were ever, really, you're reading part of the law, but the way that if I were not an attorney, the way that the law would come up to me would be that I would be reading about the law someplace else, like on my website or in a book or on rightslaw.com or someplace. And I'd be like, oh, that's not telling me enough, but it's making me curious. I'm going to go see if I can figure out the law. And I know parents do that. So if you are reading an actual statute or a regulation for that matter, and something doesn't quite make sense, you're like, oh, I'd like to know more. If something is not defined, you might go back to the definitions in the law and see if the definitions give you more information. Chances are, if it's not defined in the law, it's probably defined in definition. If it isn't, you might actually have to look at case law, like real live decisions, because if it isn't defined well in the law, then somebody's probably litigated it, and you might have to go read the the actual cases, which can be complicated, and that's why attorneys have jobs. I'm sorry to say, but that's actually something that I love to do. So, we are in section 1401 of the Individuals with Disabilities Education Act, which we use the acronym IDEA for. And, we're looking at these key terms, and that's what we're going to cover in the podcast today. Now, there are only, you'll be surprised to know, 36 key terms that are listed in here. And in fact, a couple, at least one, if not more, have been repealed. So we are at 35 or less key terms that are in here. I'm not going to go through all 35. Rather, we're going to highlight just a few of them. Before we do that, I want to talk a little bit more about kind of generally speaking, why laws exist. And I will go ahead and say, if you are watching this on YouTube and like you actually sit and watch this on your computer screen or something, yes, I am toggling between two different screens and three different things because I've got my notes, I've got you, and I've got the law. And so I'm like trying to teach this almost kind of like a professor, right? With like all my different things up. Um, as I always say, I don't think anybody's really looking at this, but if you are, that's what's happening. So the first thing I want to say is that when we look at definitions, we're really trying to prevent misinterpretation or ill interpretation. So it's almost like this proactive thing to be like, okay, specially designed instruction, for example, or well, that's not in here, but special education is. And part of the definition of special education is specially designed instruction. So we know that special education involves specially designed instruction. That's pretty clear because that's sent out proactively. Something that I don't think that Congress really interpreted or thought about proactively when they wrote this law and haven't gone back to revise is what's the definition of specially designed instruction? I gave a presentation on that with a colleague named Melissa Waugh from Virginia at COPA last year because it is a big question. What exactly is specially designed instruction? What are they teaching? Our conversation was about what are they teaching pre-service teachers? What do the cases say about it? What do textbooks say about it? What do teachers say specially designed instruction is? Um, so when we define keywords, we're trying to prevent that kind of misinterpretation or ill interpretation because things aren't as vague, right? So the first thing is to prevent a gray area proactively. Another thing that we do when we get these key terms is we really try to kind of set boundaries. We try to, I always say that people, humans, in our experiences, um, exist in under the shadow of the law. So I always tell people, and I probably said this on the podcast, but it's worth repeating 1,000 times. So hold up a pretend umbrella in the sun, which is also hard to imagine right now, but hold it up in the sun, and you're going to get this cast of shadow over top of you. And so the law, most laws are not super black and white. If they were, attorneys wouldn't have jobs, but here I am employed. So we hold up this thing and we get this shadow and we exist under the shadow of the law. So for any law, whether it's an idea or it's in the ADA or it's relative to divorces or stop sign, any law is going to have some gray area. Stop signs don't have a ton of gray area. I'll tell you, there's something called strict liability that we won't go into. So I always advise my clients under this kind of like shadow of likelihood, shadow of the law. And so for any set of circumstances, what we're really looking at is what are those boundaries of what's reasonable? And I think if there's a word that you write the most often in law school, it is the word reasonable. So this shadow of the law thing, really, when we define words, we're trying to set what those boundaries are of what's reasonable under the law. Okay. So those boundaries might be to whom the law applies or what parameters the law has, what is reasonable. We see this a lot right now. An example would be free speech. There's and what's that word? Hang on, I'm losing. There is a exception. Geez, there is an exception to free speech. There are several, but one is hate speech. So what is the line to where free speech becomes hate speech? And that's something that we see in the news a whole lot as an example of a boundary. The third thing I want to say about definitions is definitions really can, therefore, kind of the opposite of setting boundaries is definitions can set kind of this like precise thing in the law, legal precision, right? We are zeroing in on something. So again, it's this proactive process of saying, oh, we just put some language in this law that is going to be hard to interpret. And we're going to try to zero in on it proactively so that we don't have to have all of these cases that interpret what we were trying to say. Um, So we get a very defined thing. When we get the definition for specific learning disability here in a second, you're going to see that Congress even spelled out some examples of what specific learning disabilities are. And if you're in the dyslexia community, and if you have fought and fought and fought for eligibility, you're going to be really happy to know that Congress put the word dyslexia in the law, in the definition, as an example of an SLD, because they were trying to get to this really precise place. If your child has CAPD, don't worry, it also has listening and auditory. I think the word is auditory that's in the definition. We'll get there in just a second. Um, and so really, kind of our role here is to then see that when we look at the definitions, we really can empower our advocacy, because definitions in and of themselves give us elements. Like, in order to get this, we have to prove 1, 2, 3, and 4, or 1, 2, and 3 or 4, or whatever it is. Sometimes we get those elements in the definitions, which can really empower our advocacy. When it's all said and done, what we are trying to do is we are trying to take the rule of the law. Laws are rules. We're trying to take the rule of law and we're trying to apply it to our real life circumstances. And a lot of times that is as easy as seeing what the law requires and then plugging your family situation into it. So that's why I want for you to understand what the definitions do and how they can empower our advocacy. So, without further ado, we are going to dive into a few of these. I'm going to try to remember to mention all of them, and then we're going to take some pit stops along the way in order to dive in to individual specific definitions, just so I can give you a little bit of insight into how they might help your advocacy. Some are going to be super specific, like our first one is assistive technology. That actually might apply to more people than you think, because it also applies to low tech. Some are going to be very broad, like what is special education? So hang in there until we get to the S's. They are in alphabetical order, as they normally are in laws. And let's dive in, get moving. Okay, so the first two definitions that we're going to talk about go together. It's 1 and 2 on our list, and it is assistive technology and then assistive technology devices. So assistive technology, the definition is super helpful. And this is kind of an example of how we get elements. So assistive technology device means any item, piece of equipment, or product system. So remember, it can be an item like a hearing aid or a talker, like the iPad or the app on an iPad. Piece of equipment. So piece of equipment could be the actual iPad, or product system, like an application, whether acquired commercially off the shelf. Like, yes, we can ask you to buy something from Lakeshore. We can ask you to buy something from otequipment.com or whatever it is. Modified. So we can take a chair and modify it. We can take a anything and modify it, or customized. Again, there are companies that will customize something that is on the market in order to meet the needs of a unique child. So any such item, piece of equipment, or product system that is used to increase, maintain, or improve functional capabilities of the child that has the disability. So increase, maintain, or improve. Those are the three things that you have to prove if you are asking for AT. See how in the definition we can pull out specific pieces of it and say, okay, this is what they have to prove. There is an exception that we don't have to have AT that is surgically implanted. Like, schools don't have to pay for cochlear implant. Now, any definition that is in this section is going to have provisions that apply to it outside in the law. So we'll remember this definition when we get to the assistive technology further an idea, so that we know when schools have to provide assistive technology. Now we're just learning what it actually is. So then number 2 talks about AT services. And basically what's important here is that when schools have to provide assistive technology, they might also have to provide things that are secondary to that technology, such as evaluating the child for whether or not they need that assistive technology, buying it, leasing the thing, designing it, fitting it, customizing it, coordinating other therapies that are secondary to it, right? Like we get the AAC device to help with augmentative communication, expressive language, but then maybe we need, speech is definite there. Maybe we need OT in order to be able to manipulate the um, AT device in order to be able to find the things. Maybe we need eye gaze assistance with our eye gaze in order to use an alternative augmentative communication device. Training of the child, training of the parents, training of um, the staff is all on there, etc. So those are 1 and 2. Number 3 actually gives us a definition that is super important, but pretty easy to interpret. Number 3 is what a child with a disability is. So basically, what number 3 says, there's a like part A to this is basically a child is considered to have a disability under the law if they meet the eligibility criteria for one of the 13 disability categories. So this definition doesn't help us a ton because it really just says if you're eligible for special education, we're going to call you a child with a disability under this law. So a lot of people try to come to this provision when they're trying to get eligibility, and it really doesn't help. It's actually backward. First, you become eligible, and then the law is going to call you a child with a disability. Um, this also provides that a child with a disability that is aged 3 through 9, so after early intervention, which is 0 to 3, but before the age of 10, could be considered to be a child with a disability if they have a developmental delay, but developmental delay actually goes to the hands of the state. So it says if the child is experiencing developmental delays, comma, as defined by the state and as measured by appropriate diagnostic instruments or procedures. And so then it says, and it also can be one or more of the following areas: physical development, cognitive development, communication, social, emotional, or adaptive development. And it can be, that is an or. So you don't have to have a developmental disability in all of those areas. As you probably know, some states allow that DD eligibility category, some states do not. The reason why DD exists is because some students are considered to be disabled and would qualify for eligibility as being disabled because of things that, might not be attendant to something that is psychological or neurological or physical. It might be kind of secondary to lack of access to educational environment. And so we call that a developmental delay. That also could be something medical, like slow start because they had failure to thrive or because they had heart surgery and it took them a second to get started. And so basically we say, we'll call that a developmental disability, but if you have not gotten caught up by the age of 10, then you're going to have to qualify for something else because that might not be a disability. That's why DD exists. Okay. Okay, we are going to skip over the next few. Definition 4 was repealed in 2015. Definition 5 gives us educational service agency. 6 is what an elementary school is. 7 defines equipment. 8 defines excess cost, which has to do with funding. And 9 gives us the definition of FAPE. So let's stop there. Free, appropriate public education. Remember, we're going to find this other places. We know that children with disabilities, students that are eligible for special education, we just read that definition, are eligible for a FAPE. And so what is a FAPE? It's got 4 elements. If you are trying to prove that a child has been denied a FAPE, you have to prove that at least one of these things has been violated by the school. Usually we're talking about the appropriateness of it. But number 1, that the education has been provided at the public expense. So the public school has to pay for their education. Number 2, the education has to meet the standards of the state educational agency, your state board of education, like in Kentucky, that's where I practice law, it's the Kentucky Department of Education. Number three, it has to include appropriate education in the state involved. And because we don't have a definition for appropriate, we have a lot of cases that try to tease out what that level of academic and functional benefit is. The last case that really gave us some insight in that is the Ender F case, which was decided by the United States Supreme Court in 2017. And then the fourth element in our definition is that it's provided in conformity with the IEP. And so another way that we can be denied a FAPE is if the services that are listed in the IEP aren't given to the child. So a failure to provide a FAPE is a very big reason for a due process case. Something that I see that attorneys do often when they are advocating in a due process case is they don't come back to this definition and they don't look. Usually you can probably wrap your argument around both C and D in this definition. So you might be missing something because you aren't coming back to the definition. All right, carrying right along. Number 10 was repealed in 2015. Number 11 gives us the definition of homeless children, but it really just references out to another law, which has to do with this law called McKinney-Vento. Then number 12 gives us the definition of Indian as being someone who is a member of an Indian tribe or a Native American. And then 13 gives us the definition of Indian tribe. And then 14 gives us the definition of an individualized education program, IEP. We don't get a whole lot of information as to what an IEP is. We get more in the statute itself, but it says that it is a written statement for each child with a disability that is developed, reviewed, and revised in accordance with the future provisions that we get later. I think what's important is that we say that it's reviewed and revised. I have used that a lot of times in my advocacy when schools don't advance goals. And also Ender F helps a lot with this because goals have to be appropriately ambitious. But we have to review them and we have to revise the IEP. Moving right along, 15 is that IFSP that you get in preschool. 16 gives us the definition for infant or toddler. 17 gives us the definition for institution of higher learning. 18 gives us the definition for limited English proficient. 19 gives us the definition for local education agencies. Only thing I'll say about this is this means schools. But sometimes you'll see it abbreviated as LEA. LEA just means your school, your public board of education or other entity that is the same as a board of education. Then, and that also applies to Bureau of Indian Affairs. That's also in that definition. 20, native language. By the way, we're flying through just a few of these. So I'm just going to give you a few updates as we go in order. And then the next one that we're going to dive into is 26 when we get to related services. So native language is going to come into play both in parent rights and in education for the child. And it basically means the language that's normally used by the child or the individual, whether it's a parent, etc. Nonprofit is 21. 22 is outlying area. That's talking about United States Virgin Islands, Guam, Samoa, and also the Commonwealth of Northern Mariana Islands. 23 gives us the definition of parent, and it does include, of course, natural, adoptive, and foster parents and guardians. But it also includes individuals acting in place of a natural or adoptive parent, so long as that person is legally responsible for the child's welfare. Then we have parent organization, which comes up later. The only thing I want to point out there is that parent organizations exist, and we will talk about them when we get to later provisions, and they can be very helpful. which goes to 25, parent training and information centers. PTICs exist, and they are defined later or they are described later in the law, but it's just important to know that they exist because a lot of people don't know that there are such thing as parent training and information centers, and those places have a wealth of information, video trainings, and all kinds of pamphlets and information. That takes us to 26. And don't forget, we only have 35 definitions, 36. So you are hanging in there. You're doing a good job. Related services. When we talk about related services in an IEP, we oftentimes think about speech, OT, and PT. When I go to the doctor at Cincinnati Children's, they always say, what about related services at school? Are you doing speech, PT, and OT at home and, outpatient and at school? So the important thing that I want to read to you here is that related services has a very wide breadth. Okay. And the list that I give you in this law is not exhaustive, but I think it's important to know that there are other related services that are mentioned in the law, in the definition. The reason I say this is because sometimes schools will say, oh, well, you don't do that. We don't have that here. And if it is a part of the law specifically mentioned in the law, it's probably worth mentioning. So in the definition of related services, basically what this says is that related services are transportation, such as developmental, corrective, and supportive services, as may be required to assist the child to benefit from special education. Okay. That is what related services are. Now, there's this big parenthetical. So it might include speech language pathology and audiology, interpreting services, psychological services, physical therapy, occupational therapy, recreation. You can add recreation to an IEP, including therapeutic recreation. Lots of times we call that adaptive PE, social work services, school nurse services, and this one's spelled out, that are designed to enable the child to receive a FAPE as described in the IEP, counseling services, including rehabilitation counseling, orientation and mobility, which is typically for blind students, and medical services, except that those are for diagnostic and evaluation purposes only. Don't have to provide medical care in school. Okay. That is not an exhaustive list, but if it's important enough for them to put it in the law, I thought that I would read you that list. Of course, the exception exists that surgically implanted things don't have to be included, as like the replacement of those don't have to be included in the law. Okay, trucking right along. Secondary school is, secondary school. Secretary means the Secretary of Education. That's 28, 29. Our definition of special education. Now, as I said, this is a case. Remember how when I said that, I'm scrolling up here, that learning about the definitions gives us kind of like legal precision so that we narrow in. This is an example of where we get some legal precision and then where we have a lot of interpretation for the law. Because the term special education means specially designed instruction, hold that thought, at no cost to the parents, to meet the unique needs of the child with the disability, including two things. Number one, instruction conducted in the classroom, in the home, in hospitals and institutions and other settings. That just says wherever it's done, we're going to follow that continuum of placements that we find later in the least restrictive environment provision, and also instruction in physical education. I find it unique and interesting that they spell out PE, but that's what it says. But going back, special education means specially designed instruction. No place further do we get a definition of specially designed instruction. And so we can see that special education now has a definition, but we've got this vague term, specially designed instruction. What does that mean? That's something that's kind of left for interpretation. Okay. Number 30, specific learning disability. Yay! This helps all of you in the dyslexia and other SLD. Now, the definition itself doesn't give you a whole lot. To really find out about eligibility for SLDs, it's important to go to the eligibility provisions, which we will dive into in a future episode. Basically, what it says about eligibility is that an SLD is a disorder in one or more basic psychological processes. We know that these are neurological disorders, right? They happen in the brain that involve understanding or using language, spoken or written. So that's where the auditory part is, which might manifest itself in an imperfect ability. I think that's a good phrase there. Imperfect ability to listen, think, speak, write, spell, or do math calculation. That covers most of the SLDs. Then in Part B, we get an example. So in the law, they specify perceptual disabilities, brain injury, minimal brain dysfunction, dyslexia, and developmental aphasia. I think it's super important that those things are mentioned. I said Cat D when I was talking about the about this in the introduction. It says imperfect ability to listen, and so that's really kind of that process of listening, and then turning some things, turning it into something as you process it, central auditory processing disorder. So 30 is our definition of specific learning disability. We don't have a whole lot more that I'm going to stop on. So we are reaching the end here. 31, definition of state, which includes DC and Puerto Rico and outlying areas. 32, state educational agency. As you can imagine, it's similar to local, it's just at the state level. 33, we get the definition of supplementary aids and services, which is a specific part of the IEP. I find this interesting because we don't get other specific parts of the IEP mentioned in the definition. We don't have a definition, for example, of present levels of academic and functional performance, but we do get a definition for SAS, those supplementary aids and services. One thing I tell you when you read laws is you have probably said SAS, supplementary aids and services, 1,000 times in your life. But have you ever stopped to think, oh, these are things that aid and provide additional services to my child or to my student? Super easy. And they supplement which is provided. Sometimes if you just look at stuff, it is so basic, and that really can help us. So supplementary aids and services supplement what is provided in the gen ed environment. The definition is aids, services, and other support that are provided in regular education classrooms. So SAS are provided in gen ed classes or other education related services like special classes and resource rooms in that place, those kinds of places that enable kids with disabilities to be educated with their non-disabled peers to the maximum extent appropriate. What I think is important here is that the definition of SAS itself really talks about LRE. It really is founded in inclusion. 34 is transition services. If there's anything I know about this group, it is that we don't focus on transition services. You will, I think my audience is really mostly younger parent. But I think transition services are largely abysmal in most districts that I'm in. So we will focus on transition services in a future episode. I promise when we get there in the law. 35 is universal design, and that's really exciting, except it doesn't really give us a definition. It just kicks us out to section 3002 of Title 29, which is not even idea. 36 tells us what a ward of the state is, and ta-da, we are finished going through the definition. I hope that what that does is give you some very good information about elements, about examples of things, and about ways that we can use these things. At the very least, I want for you to understand that as we are going into the future, that we might circle back and come back to what the definition of these phrases and words are, because that can help us in our advocacy in the future. So I will see you next week, same time, same place. And in case you want a little preview, Next week, we are going to talk about the Office of Special Education Programs, OSEP, and I hope to provide you a little bit of information about what OSEP does and some examples of some of their guidance. I will see you there.